Hey everyone! Today, we're diving deep into the intricacies of Philippine civil procedure. We're going to unpack everything you need to know about filing a complaint, serving summons, pre-trial procedures, and so much more. Alright, let's kick things off by talking about the complaint. The complaint is an initiatory pleading that starts off a civil action. Now here's the thing, a complaint doesn't need to be overly complicated. It just needs to state the ultimate facts that constitute the party's claims. You don't have to include conclusions of law. When you file a complaint, you're essentially kicking off the legal process. But remember, it's not just about filing the complaint, you also need to pay the docket fees. This payment is crucial because it enables the court to acquire jurisdiction over the plaintiff. Let's break down the parts of a complaint. 1. Name of court. 2. Title of action. 3. Name of parties. 4. Docket number. 5. Body of pleading. 6. Relief. 7. Signature. The complaint must state a cause of action. Now let's talk about cause of action. Here are the elements. 1. The plaintiff must have a legal right. 2. The defendant must have an obligation to respect that right. 3. There must be a violation of the plaintiff's right. 4. And finally, there must be damage or injury as a result. If all these elements are present, then it gives the injured party, the plaintiff, the right to file a suit. But here's an important point. You can't split a single cause of action and make each part the subject of a separate complaint. It's one cause of action, one complaint. Let's move on to summons. Once you've filed your complaint and paid the docket fees, the clerk of court will issue summons to the defendant. It's how the court acquires jurisdiction over the person of the defendant. The purpose of summons is twofold: to give the defendant notice of the case and an opportunity to respond, and to acquire jurisdiction over them. Remember, summons are valid until served. Now let's talk about the answer. The answer is the defendant's response to the complaint. It's their chance to either admit or deny the allegations against them. If they fail to raise certain defenses in their answer, those defenses are deemed waived. If the defendant believes that the plaintiff's evidence is insufficient, they can file an affirmative defense and raise failure to state cause of action. This is basically saying, hey, I have no violation. After the complaint and answer stage, we move on to pretrial. Pretrial is a crucial stage where the court sets the timeline for the case and identifies the issues to be resolved. Within 5 days after the filing of the last responsive pleading, the clerk of court schedules a pretrial conference. During pretrial, the parties submit their pretrial briefs, outlining the facts, legal issues, and evidence they intend to present. The court then issues a pretrial order, summarizing the agreements made and issues to be resolved during the trial. If a party fails to file a pretrial brief, the court may dismiss the case with prejudice. The purpose of pretrial is to streamline the case, identify areas of agreement, and explore opportunities for settlement. But what if the case doesn't settle during pretrial? A court-annexed mediation is mandatory where parties will try to settle. If still not settled, then it's time for trial. The order of trial typically follows this sequence. 1. The plaintiff goes first, presenting witnesses, documents, and other evidence to support their case. 2. It's the defendant's turn to present their evidence to counter the plaintiff's claims. 3. If there are any third-party defendants or counterclaims, they present their evidence next. 4. Finally, any parties against whom counterclaims or cross-claims have been pleaded present their evidence. Judgment. After both parties have presented their evidence, the court renders a judgment. This judgment should be based on the evidence presented during the trial and the applicable law. Demurrer to evidence. But what if after the plaintiff rested its case, the defendant believes that the plaintiff's evidence is insufficient? Well, they can file a demurrer of evidence. This is a legal maneuver where the defendant essentially argues that even if everything the plaintiff said is true, it's still not enough to win the case. If the court grants the demurrer of evidence, the case is dismissed. If not, the defendant proceeds to present their evidence. Now let's talk about post-judgment remedies. Once a judgment is rendered, parties may seek remedies to challenge or enforce the judgment. These include 1. Motion for reconsideration. This is a request asking the court to review its decision based on errors of law or fact. It must be filed within 15 days from judgment. 2. Motion for new trial. This motion asks the court to re-examine the case based on newly discovered evidence or errors in the trial process. It must also be filed within the period for taking an appeal. 3. Appeal. If a party disagrees with the court's decision, they can appeal to a higher court. The appeal must be filed within 15 days from notice of judgment. And finally, the execution and satisfaction of judgment. And that is a comprehensive overview of Philippine civil procedure from complaint to post-judgment remedies. Until next time, keep learning and advocating for justice.